right. So let's get into some new stuff. We're coming now to trials, right? And juries, of course, is a part of the trial unit. It's kind of anticlimactic, right? Trials are extremely rare. Only 2% of civil claims which are filed in Ontario ultimately make it to a trial. Perhaps 5 to 10% of them are adjudicated in some way, right? So there'll be some kind of motion hearing and adjudication, 5 to 10%. 90% simply just settle without any judicial hands on them. So we have the trial, which sounds unimportant. Only 2% of cases get there, but it's important in other ways, right? It's kind of, the trial is important as sort of a specter or a threat, which looms over the parties as they are going through all the stages of civil litigation. Because even though you're generally going to walk this road with the goal of getting a favorable settlement for your client, doing so often requires a credible threat of a trial, right? So in fact, the way that great civil litigators produce great outcomes for their clients is by using the stages of civil litigation to create a credible threat that the matter will be adjudicated favorably for your client. And that is what brings the other party to the table and gets them to give you a favorable settlement. So that's one reason why trials are important, right? This threat. Trials are also important because an anticipation of the trial shapes what happens in these other phases. So you recall at the pleading stage, the documentary conversation that opens the civil case, the parties are defining the issues for trial, should a trial ever exist. And you're pleading expansively and you're putting all of your possible arguments on the table, because if it does get to trial, you want to have maximum latitude to develop the case in the manner that suits your client's interests. We also talked about trials when we were talking about discovery, right? And we looked at the strategic use of examination for discovery to commit a witness to a certain version of events, which can then be contrasted with what they say at trial in an effort to impeach them. Because you want to get, even if you don't think you're going to sort of get that smoking gun in examination for discovery, it's still very important to get the examinee's version of facts on the table so that you can set that up to compare it to what they say at trial. So what we're going to do with trial, we're going to actually look at how a trial unfolds. We're not going to spend much time on this. There's a great upper year course called Trial Advocacy that I would recommend to you if you want to actually get your hands on a trial. It's a practice-based course. So we're going to look at the order of a trial, and then we're going to watch part of an actual trial to kind of illustrate it. Okay, this is what happens in what order. So it starts with the plaintiff's case, and in the plaintiff's case, you begin with opening statement where you lay out your theory, establish what it is that your evidence is going to demonstrate. You then conduct an examination in chief of your first witness. So an examination in chief, you'll see it when we get to the video clip, but that is the process of you use with a friendly witness to get them to tell their story in their own words. The defense then has the right to cross-examine that witness. And then in certain cases, the plaintiff will have the right to re-examine the witness if there's something that needs to be re-established. That's kind of a detailed procedural thing we won't get into. In a case with multiple parties, so if you're suing two defendants, then each defendant will have the right to cross-examine the witness themselves. So you basically go through that with all your witnesses. If there's exhibits, which is to say documents, photos, things like that, which constitute evidence, then they are admitted. There's the process you'll learn in evidence by which evidence is scrutinized, and then you basically proceed through that. That's followed by the defendant's case, which is basically all the same stuff, but in reverse. The plaintiff has the same right to cross-examine. The defendant questions their witnesses and leaves their evidence. If there is a jury, so the brackets there are meant to represent the fact that this stage only happens in a jury trial, the plaintiff and defendant address the jury about the facts. So it's kind of like a closing statement in criminal law. If there's a jury, the judge will charge the jury, which is to say explain to the jury what the legal questions are, or what the law is that sort of sets up the factual questions that the jury has to answer. The jury will issue a verdict if it has one, and then the judge will make an order. So one thing to know about this is that it's unlimited in length, in principle, right? That little ellipsis there after witness number 2 represents the fact that if the plaintiff has 48 witnesses, then in principle they can have them all called and examined, right? And so this is one of the things that makes trials potentially very long, in that the trial is as long as it takes for all the evidence to be introduced. It's not one of those processes in civil litigation which is kind of limited by proportionality considerations, which is one of the reasons why it happens so seldom, right? Because it's an open-ended process in terms of expense and time. Okay, so this is the case I wanted to show you, 733 LLC versus Scottsdale Insurance, not a case that is studied or read in any law book or law class anywhere. It's a totally garden variety contractual dispute between an insurance policyholder and the insurance company. And so it's definitely not damages, right? It's not played for drama. It's an American case. I can't give you a Canadian case because Canadian courts don't allow cameras in lower court trial rooms. So we have to make do with the American stuff, but there's nothing substantively different between their trial procedure that you'll see and our own. So it's a case about this chap, Jeff Caudill, a real guy, right? He lives in the town of Atchison, Kansas. Anyone been to Kansas? This is a classic sort of Kansas-type small town. And Jeff he's a teller at a bank, right? He works at a bank just down the street from this property. And every day he walks to work and then he walks back to lunch, he goes past this property, and he thinks, this is a real beaut, I've got to have it. It's a building that's got 3 storefronts. There's apartments and offices on the top, and then on the ground floor, which is now vacant according to that picture, was a tavern named the Duck Inn and Waddle Out, which is just best name for a bar in the world, in my view. But so he passes it. The building's for sale. This is around the year 2000. And Jeff and a few of his buddies decide to get together and buy this building. So they form a corporation in which to do so. They don't waste any time thinking up a funny name for their corporation. Their corporation is called 733 LLC because this is 733 Commercial Street. That's the address of it. And they buy the building. Okay, so now they have this asset, and like conscientious business people everywhere, their minds turn to insuring their asset to protect it. And they take out an insurance policy in January of 2010 from the Scottsdale Insurance Company. Okay, so this is what the insurance policy says. It says, we will pay for any direct physical loss or damage to the property if it's caused by abrupt collapse of a building or any part of the building that is insured under the form, if that abrupt collapse is caused by any type of building decay that's hidden from view, unless the presence of the decay is known to an insured prior to collapse. And then they buy some additional coverage, right? So an additional rider on the policy saying the collapse does not apply to any building or part of the building that is in danger of falling down or caving in. So the type of language you'll often see in an insurance contract, sort of like, yes, we're covering you, but we're not covering you if it's in this category, and we're not covering you if it's in that category. So various things which limit the coverage. And kind of naturally, right? Because if you're in the insurance company, you definitely don't want to be on the hook for people who've had buildings that have been decaying for a long time, and people know the buildings will fall down, and they go and buy an insurance policy, and then it falls down the next month, and you've got to cover for $1 million, having only collected premia for a couple of months. So not unusual terms for this type of property insurance contract. Okay, so life is good for Jeff and his buddies. They've got their new building, and they've got their tavern, and they've got some tenants. Life is good until mid-July of 2010, when some of the tenants at 733 Commercial complained that the door was not closing properly. So if the door is not closing properly, it's good news if that's just because there's something wrong with the door. In this case, there's nothing wrong with the door, there's something wrong with the frame around the door. And basically there's something wrong with the whole building. The building is shifting and slowly moving, and that's why the door stays the same size. The plaster around the door is shifting. Okay, so July 27th, a couple weeks later, things get even worse because the building department of Aitchison, Kansas sends someone around who tells Jeff that there's extensive exterior damage due to a number of structural failures in this building, and basically the whole thing is a potential death trap. So they close the building, duct in and water out is not open for business, barricades all around the building. So Jeff and his partners, they start repairing the building a couple weeks later on August 10th, but it's too late. On August 7th, the entire exterior facade collapses. Fortunately, no one was hurt, but this is $70,000 in damages caused to the building. So fortunately, they've got their trustee insurance policy, and they make a claim to have this $70,000 reimbursed. The Scottsdale Insurance Company says no dice, right? They say we're denying coverage because the cause of loss, the collapse was not hidden from view, right? So the building collapsed, the insurance company says, because of this structural deficiency, which you knew of, or you should have known of, it wasn't hidden from view, therefore it's not covered. Jeff does not take this lying down. He brings this lawsuit, right? They say it's the simplest contract dispute you can imagine, right? That it's about whether or not they are entitled to a payment to compensate them under the terms of the policy. So they issue their pleadings. Both sides move for summary judgment. That's denied to both sides, and they go on to trial. Okay, so it's a simple case. It's a pretty simple trial. There's a jury, you'll see, which there never would be. This is one big difference from Ontario. You would not have a jury in Ontario for a case of this nature, like such a simple case with such a relatively small amount of money at stake. The Americans, however, have a constitutional right to a civil jury trial. For some reason, the Seventh Amendment to the American Constitution guarantees you the right to a jury trial in a civil matter for any civil matter worth more than $20. This is why written constitutions are so wonderful, right? I mean, this seems like a great idea in 1840, this $20 threshold, but now because of that, groups of 6 or even 12 people are forced to waste their time watching cases like this, right? We're here, we just do it in small claims court. Okay, so the issues before the judge, right, and before the jury are, was this collapse abrupt, and was the nature of the collapse such that it fits in the exclusions of the insurance policy, or such that it fits within the general obligation of the insurance company to pay? So what I'd like you to do, if you could open the participation questions for next time, set number 9. There's a couple of questions at the beginning there about what you're about to see. So what are you about to see? Well, first of all, I'm going to show you the opening statement for Paul Hasty, who is the lawyer for Jeff, lawyer for the plaintiffs. There he is. And so I guess as you watch him, maybe just sort of think about what he's trying to do, right? How does this work or not work as advocacy? Recalling that in civil litigation, advocacy is to a large extent, a question of storytelling, right? Kind of creating a compelling narrative that is based on the facts and explains all the facts, but a narrative which makes any human audience sympathetic to your client and disposed to give them what they want. Okay.
The near panel, I'm going to tell them a little.
That's the judge. It's a beautiful Kansas accent. I love it. But we'll maybe go ahead to his opening statement up here. Unfortunately, it's you see him from the back, the lawyer, but hopefully you'll be able to hear him anyway.
Any questions to you? The plaintiff in the case always has the burden of proof, meaning that the plaintiff has to prove that its claims are more likely true than not true in a civil case. It's called proof by a preponderance of the evidence. The party with the burden of proof gets to go first. And so, Mr. Hasty, if you're prepared, if you'd open, please.
People able to hear it?
You can turn that around however you want to.
Morning, folks. My name is Paul Hasty. I'm here on behalf of 733 LLC, a little company that owns, organized, purchased, and owned a building in Atchison, Kansas, on Commercial Street in Old Atchison. They bought it in 2001. Excuse me, just getting over a cold. Mr. Caudle is here. He is a member of 733. He's actually vice president of the bank in Atchison. He and three of his acquaintances bought this old building. An effort was undertaken in downtown Atchison to renovate downtown. There are some buildings there that are 100 years old. And so this was a city beautification, modernization kind of project. It was purchased in 2001. This is a two-story building with a basement. And at the time it was purchased, it was not in very good shape. There had been water intrusion. You could see water damage, water stains inside the building on the ceilings and on the walls. The second floor was really set up to be a living quarters for someone, and it hadn't been used for some time and wasn't used after Mr. Caudle and his group bought the building. It wasn't used at all. There is a tenant. The major tenant is downstairs. It's a family-operated bar and lounge owned by a tenant. They actually rent the space from Mr. Caudle and his business associates. Excuse me. They've been there for a number of years. It's a lounge and private club on Commercial Street in downtown Atchison, Kansas. Well, that was all in 2001. The tenant's been there for many years. At the time the building was purchased, as I said, you could tell that there had been water in the building. There were stains on the, particularly upstairs, but in the basement as well, on the walls and ceilings. And so the roof was inspected. It was inspected by more than one person. In 2007, it was overlaid because Mr. Caudle and his associates were concerned, and they had some preventive work done, not because it was leaking, just as a preventive work. It's a flat roof, and it was overlaid. There was a contractor on the roof not long before this incident occurred because there was an issue with regard to a pop-up vent. And instructions were, if you see anything that needs to be done on the roof, fix it. That was all well and good until the summer of 2000. And in the summer of 2000, the tenant, the lady that operated the private club, what did I say? 2010, thank you, I misspoke. Summer of 2010, the lady indicated that the front door wasn't closing quite right. So Mr. Caudle went there, and what he saw was around the door frame, and now we're talking about the door entrance from street level. So we're on the main floor of the building. There's a crack running from the left side of the door. As he looked up at the top, he could see a crack in what's called the parapet up at the very top. Mr. Caudle's a banker. He didn't know what that was. So he contacted a contractor. The contractor said, we need an engineer to see what this is. So the engineer, Mr. Schulte, came out. And it was Mr. Schulte's opinion that what had occurred years ago was causing a problem. This building originally had square corners, much like the corner of the tree. At some point, this past, someone had cut off the corner, made a diagonal side of the building. That's where the door was. That made it kind of fine. They just cut off, put a more brick facade there. This building was brick. And Mr. Schulte said, down at the bottom, when they cut that corner off and put that column in there, that's a supporting column of brick, they only used half bricks. They didn't use the full thickness bricks, they used half. And he thought it was losing its support. That's what he said. So Mr. Caudle arranged for a contractor that was going to be there July 10th to fix this problem. The city had come and inspected the building and said, we're concerned about that crack up at the top. We're going to close the sidewalk here because we're concerned about that brick up there at the top, which means the bar had to close because now you can't get in the front door, the lounge. That was all done in late June, early July. On July 7th, the building collapsed. The top fell to the sidewalk. On the following Monday, July 10, the contractor was scheduled to come fix the problem with the support column down on the first floor, but it collapsed 3 days ahead of time. Now, at the time of this collapse, 733 had an insurance policy with Scottsdale Insurance Company on that building. And the basic policy doesn't provide any coverage for collapse. You have to buy that. There was collapse coverage on this policy at the time of the collapse. But Scottsdale denied the claim, saying that you knew or should have known because it wasn't hidden from you the reason for this collapse. What happened is this. An engineer was dispatched. You'll see he wrote a letter to the adjuster that Scottsdale used. It's called Eagle Adjusters. And he said that collapse at the top was due to two things. Number one, over the years, water got inside the bricks themselves, the bricks that form that wall. And in the winter it freezes, summer it thaws, that cycle weakened the brick. But there was a problem with the inside of the brick. And he'll tell you, no, you couldn't see that until the wall collapsed. He'll tell you that, in his opinion, there's a problem with the linkage between the floor joists on the second floor. Again, using the jury box for the purpose of the screen. This is a two-story building, as I said. You consider the top of the jury box here as the top of the first floor. Got another floor on top of that. What the engineer said was for the floor joist of the second floor, that would be the roof of the first floor. Connected to the wall, there was a problem right there. Where they connected, and the wall separated out. Right there. You'll hear what Mr. Schulte said was that the problem he found was down here at the bottom of the first floor. The engineer, Mr. Sommer, that Scottsdale and its adjuster sent out, will tell you that when you can't see that connection between the end of the floor joist of the second floor and the wall, the walls, but it's connected, it's covered. And the issue here is whether 733 knew or could have known, because it was not hidden from view, the decay that caused the collapse. You'll hear that word decay a lot. Mr. Sommer will tell you that there's decay inside the bricks and there's decay at that joint, and he says that's what caused the collapse. Excuse me. Of course, once the building collapsed onto the sidewalk and street, it had to be cleaned up. It was, the building has been fixed. The damage is somewhere around, the expenses somewhere around the $70,000. You'll be asked to determine issues of fact with regard to whether this insurance company should pay for that collapse. The building has been repaired, and the insurance company refused to pay for any of it. Excuse me. We think the evidence will be that the two problems that Mr. Sommer identified as causing this collapse were ones that could not be seen until the collapse occurred. Mr. Schulte will tell you that he didn't go after the collapse. He didn't see either one of those problems. He's an engineer as well, and he was there, but he was only there before the collapse occurred, and he's the one that identified the problem down there at street level. You'll see some photographs. It's obvious that this is an old building. Mr. Caudle, I think, can tell you when it was built, but we're talking 100 years, I'm sure, ballpark. And over the years, there was water in the building. He'll tell you that those water stains were there on the unused parts, not down where it was rented to tenants and used by tenants. When they bought the building, they'll tell you that after they bought the building, they had no problems at all with water intrusion. They didn't fix the upstairs part because it wasn't used. It was never rented to anyone, wasn't set up to be rented to anyone. Matter of fact, if they were going to use that to be rented to someone, there'd have to be some major structural changes made because of hallways and stairways and that kind of thing to separate it from the tenants on the first floor, and so it just wasn't set up that way. But at the conclusion of the evidence, we'll come and ask you to make the findings that this building collapsed, when it collapsed, and what the facts were. Thank you.
Thank you, Mr. Hasty.
Okay, so that's the opening statement, right? I just want you to see what this is about, just in case you're called to the bar and in your trial, whatever avenue you're on one. You lay out, you say what the evidence is going to be. Right? You use that phrase a few times. You think the evidence will say this, and you're also positioning your client as the good guy. And sometimes that comes through in the language uses, right? So he never talks about a tavern or a bar. He says it's a family-owned lounge, right? 6 really conservative people in the jury hearing this in Kansas. You want to position your client not as like the slumlord of a tavern, but rather as a family guy who owns a family lounge. So anyway, it comes through. Okay, so what happens next is basically Jeff is examined in chief. So basically, over the course of 40 minutes or so, let's see, where's the part with Jeff up on the stand? Jeff, where are you, my friends? There's Jeff, right? Didn't bother to dress up for court too much. But anyway, so he's up there, and then Paul Hasty, his lawyer, takes him through the examination in chief, asking him questions, getting him to tell his story, yeah, just takes 40 minutes basically to get out the simple facts that I told you in about 5 minutes. Okay, so now we come to the cross-examination of Jeff. So Jeff is a really important witness. He's not just the plaintiff, he's also the person who knows all about what he knew when, right? Because the question comes down to how much this collapse or the evidence of the imminent collapse was available and known to the partners before it actually happened. Because the more available and known it was then, the less likely it is the insurance company is going to be on the hook. Okay, so this is at 139. 905.
Now, back available.
It is, yes.
So think about what
Buchanan.
the defense's lawyer is trying to establish in the cross-examination and what he does to try to do it. It's just about 5 minutes.
Mr. Caudle, when Mr. Schulte came out at your request after the city had shut the building down and barricaded off, he gave you a report, didn't he?
Yes, he did.
And in that report, he told you that that building was in structural failure, didn't he?
I'd have to see the letter to tell you specifically what he said, but that there was a column failing, I believe was part of the wording.
The southwest corner first floor brick column is failing, correct?
That was in the letter, yes.
And he also told you, because you asked him to give you recommendations of what to do to fix this crumbling building, didn't you?
Yes.
And that's because the city had shut that building down and told you, and I think that was Exhibit 400, that the building shall remain unoccupied until a plan of correction provided by a Kansas licensed engineer with structural expertise is provided to the code enforcement office. True?
That's correct.
And so that's why you contacted Mr. Schulte.
Yes.
And Mr. Schulte came out there and he told you about all these structural problems, and he'll be testifying later today. But he also told you that it was his recommendation to fix the problem so that you could reoccupy it, to take that wall down from the top all the way down to the ground.
That was his recommendation.
So before August the 7th, the day that the rest of it fell off, you had already been told by your engineer that to rectify this crumbling building, that you needed to remove that wall all the way down and rebuild it. True?
That was in his letter, yes.
And that's exactly what you did after August 7th, when the rest of it fell down. True?
Correct.
So let me get this. Had someone gone out there and shored that wall up, they would have eventually come out there and torn it down at your expense and rebuilt it. True?
I would say that's probably true.
Okay. And certainly you didn't call Scottsdale Insurance after Mr. Schulte told you what needed to be done and said, Scottsdale, I need you to pay for this, did you?
I did not contact an insurance company until later in the month of August.
Yeah, and you did that only after this collapse occurred. True?
Correct, it was after.
And had someone gone out there and shored that building up, and then your contractor got out there and was able to tear it down and rebuild it, you would have been turning this into Scottsdale, would you? Because it wasn't covered under the policy.
I don't know that. I had not reviewed it with my insurance company yet.
All right. Well, there wouldn't have been a collapse at all then, would there?
I suppose not.
Or are you saying that it was already collapsing?
I wasn't thinking about whether it was collapsing or not.
All right. Well, there's no question that July 27, 2010, you got this letter that was marked as Exhibit 400, and you were told that the city was going to shut that building down and barricade the sidewalk and a portion of the street to reduce the public exposure to sudden dramatic failure and collapse, right?
That was in the letter from Mr. Fay, yes.
I mean, so you're not telling this jury that you had no warning that there's a potential failure, are you?
No, we knew.
You knew what? That it would fail?
I had a letter from the city inspector saying that we need to close the sidewalk because he was concerned of items falling off the building to the sidewalk.
Now, it's true that even before the city came out there, first of all, the city came out there unannounced and inspected that building, didn't it?
Yes, they did not notify me.
You only found out about it after Mr. Fay had done his inspection.
Correct.
And contacted you, right? And even before that, you had seen that there was a problem with that building before the city did. True?
Well, when I was there and inspecting the front door, since the building was so freshly painted and it had a fresh coat of paint on it, any cracking would be evident even from the street, and there was evidence of cracks towards the top of the parapet wall, as I already testified when I was there when the door was sticking.
Looking at what I put on the screen there is Exhibit 14 that was offered as in evidence. When you talk about the parapet wall, are you talking about this part of the wall out pointing to my finger?
Yes, the very top of the wall. You can see the roof line there, yes, where your finger is now. The parapet is anything above that roof line.
So before that part of the building fell off, there was a real line, like I'm moving my finger across there. That would be the parapet wall that was there before the city came out and told you to shut the building down.
Correct.
And you saw a crack up there in that parapet wall, true?
Yes.
And that's the same parapet wall that eventually fell off the building, true?
Yes.
And just so we got this straight, looking at that photograph, this is a photograph, I believe you said, that was taken before the the city came out and hired this contractor to knock more of the wall down?
Mm-hmm.
Is that a yes?
Yes.
And so this would show what had fallen off before the city came out and used some equipment to knock out more of the wall.
That is correct.
All right. And I take it, based upon what Mr. Schulte told you back on the 29th or 30th, he was recommending that those same parts of the wall be removed and replaced. True?
Yes.
And so after Mr. Fay had told you on the 26th or 27th that that wall was in danger of collapse, within 10 days, it did in fact collapse, didn't it?
He told me on the morning of Monday, the 26th, verbally. He told me in writing the next day on the 27th. And then it fell early morning on August 7th, the night of August 6th.
It's about 10 days, right? So yes?
Yes.
I don't mean to be rude, but
Yes, 10 days, approximately 10 days.
okay. You're not here to tell the jury that there was no warning that this would potentially collapse, are you?
No.
Because that's a true statement, there was a warning.
Yes.
And isn't it true that there had been some bricks that had fallen off that building before August the 7th?
I don't have a memory of that.
Well, if Mr. Schulte testifies that he understood when he came out there that bricks had fallen off that southwestern corner, are you saying that's not correct?
I'm saying I don't know that.
Okay. You have any pictures, or did you take any pictures of that southwest corner between the time that the city told you to shut down the building and start barricading that? Do you have any pictures taken?
No.
So you don't have any pictures that showed what was falling off the building during that time?
No, I don't remember.
That's overruled. He's already testified he's not aware of it.
Okay, so that was an objection, right? So that was Hasty, the plaintiff's lawyer, objecting to that question for being repetitive. You may have seen a certain circularity, or not to say repetitiveness in this cross-examination, but that's what that's about.
No further questions, Your Honor.
Thank you. Mr. Hasty?
Okay, so he's done. It's obviously a different tone, right? When you move from the opening statement examination achieved into this cross-examination, right? It's a more confrontational, hostile tone. It's just like the examination for discovery, where you were trying to get him to admit things which will undermine his case, and you have this closed type of questioning, right? The examiner only asks questions where he knows the answer, hopefully, and he asks yes or no questions. He's kind of abrupt. He sort of cuts the witness off, and that's allowed. You may have noticed a couple times, like he's trying to kind of channel the witness into like admitting, undermining fact X or admitting undermining fact Y. So these are all skills that come over time, but you'll see it's also not a rocket science, right? Even if you do have to do this your first week after being called to the bar, if you're prepared, it's not impossible for any of us. Okay, so the last little bit, I won't even show you, but anyway, I'll just say the last thing that happens here is we get this guy, Schulte, Joseph Schulte, who's the engineer. He's qualified as an expert witness, which means they have to ask some questions about his credentials and his resume, just to have his testimony accepted as expert testimony, as you know from evidence. And then what happens? Well, the parties, they adjourned for the day. They went through about 3 or 4 hours. They adjourned for the day, and the parties entered into a settlement. So between the evidence being heard and the jury having a chance to issue a verdict, the parties chose to settle, which happens, right? So halfway through the trial is not necessarily too late to settle your case. And the incentive the parties have to settle to avoid the risk of getting sort of an all or nothing win or loss is one which still motivates a settlement. And clearly what happened in this trial, and I think it probably was not going as well as the plaintiff hoped in terms of the admissions that there was other thing. So that probably changed the settlement number from what it would have been before the trial. Okay, so I think we'll leave the other stuff for Wednesday when we meet at 5 p.m. online. If you can try to tune in live, if at all possible, that would be terrific. Thanks very much.